Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host a Courthouse Steps decision on Catholic Charities Bureau v. Wisconsin Labor and Industry Review Commission, featuring Eric Rossbach, Vice President and Senior Counsel at the Becket Fund for Religious Liberty. Our moderator today is Professor Michael Moreland, Chair of the Federalist Society's Religious Liberties Practice Group, and University Professor of Law and Religion, and Director of the Eleanor H. McCullen Center for Law, Religion, and Public Policy at Villanova University. If you'd like to learn more about today's speakers, their full bios can be viewed on our website, fedsoc.org. If you have a question at any point in today's program, please enter it into the Q&A function at the bottom of your Zoom window. We'll do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, Professor Moreland, thank you for joining us today, and the floor is yours.
Thank you, Marco. I will introduce Eric Rossbach briefly, and then we will start our conversation about this important case that the Supreme Court decided yesterday involving Catholic Charities. Eric Rossbach is Vice President and Senior Counsel at the Becket Fund for Religious Liberty, where he has served since 2003. He has briefed over 90 cases at the U.S. Supreme Court and has led or been part of Becket litigation teams in each of their path-breaking victories, including Hosanna Tabor, Hobby Lobby, Holt v. Hobbs, Zubik v. Burwell, Agadoth Israel of America versus Cuomo, and Fulton versus Philadelphia. In 2020, he argued Our Lady of Guadalupe School versus Morrissey Baru to the Supreme Court, winning a 7-2 victory for his Catholic school clients there. And for more of his biography, you can find it at the Federalist Society website, linked at the email and website for this webinar. Welcome, Eric. And first, congratulations. It's always a win, whether one wins, I suppose, 5-4 or 9-0, but you ran up the score. You won a unanimous victory at the Supreme Court yesterday, so congratulations. And for people who may be new to this case and haven't followed it so far, didn't listen to some of our earlier programs about it, maybe you could just say a little bit about what the case was about, some of the procedural background to it, and then we'll get into what the Supreme Court decided yesterday.
Great. Thank you, Professor Moreland, for that introduction. And thank you to Marco and the Federalist Society for convening this webinar. I do think it's an important case, and it's going to have effects over many years going forward. It's a little bit complicated background, so bear with me, and please interrupt me, Professor Moreland, if I'm being too arcane. It's a case involving unemployment compensation taxes, and specifically the scope of religious exemptions to that kind of tax. So all states have these kinds of taxes. They're designed to build up a fund within the state to then cover employees who are let go, or if their company goes bankrupt and people lose their job for whatever reason, they can apply for unemployment compensation from the state. And these systems exist in all 50 states. Wisconsin was one of the first ones to have such a system back during the sort of progressive period. There's also a federal law, the Federal Unemployment Tax Act, that governs a lot of the way the taxes work here and gives employers somewhat of a federal tax rebate if the state system complies with that. So all of the state systems comply with this federal statute in order to obtain that benefit. Okay, that's the big structure. What happened in this case? Well, I represent Catholic Charities Bureau of the Diocese of Superior, Wisconsin. So this is a diocese, a Catholic diocese in the far north of Wisconsin, very rural area, very spread out. And they have a number of subsidiary entities that carry out different ministries, and including, for example, helping the developmentally disabled have a job, or helping the poor, helping hungry people. They also have a housing that they provide to seniors or to other people who don't have enough means. So it's really very much focused on what you might think of as classic Christian charitable activities. And those, but importantly to this case, a number of those entities are separately incorporated. So the ministry is sort of, that owns the housing block that they provide senior housing. They may have be separately incorporated under Wisconsin law. And this becomes important because under Wisconsin law, this tax exemption that my clients were seeking, to get it, first of all, if you're a diocese or a church or a synagogue, you just get it sort of automatically. So if you're a church, you get the exemption. But what happens with entities that are not themselves churches? So they're separately incorporated, but they are controlled by a church or a synagogue or mosque, what have you. And there you have to prove that it's controlled by a church, so that there's a control requirement. And then you have to show that it's, quote, operated primarily for religious purposes, end quote. And those 5 words are the 5 words at the heart of this case. And the dispute was whether Catholic Charities and its subsidiary entities were operated primarily for religious purposes, because they carry out activities, charitable activities that many other organizations who might be religious, might be secular, carry out. So for example, if they're providing senior housing, other organizations provide senior housing too. So does that mean they're not religious anymore? Now, we felt it was a little bit absurd actually to say that they're not religious and that they're not operated primarily for religious purposes, but the Wisconsin taxing authorities saw it differently. So almost a decade ago, my clients, this is before I was involved, but my clients started seeking this tax exemption for Catholic Charities and some of its subsidiary entities. And the taxing authorities said, no, if you had done some proselytization, or you had said, you must attend Mass before obtaining whatever the benefit is, getting the developmental aid, what have you, then that might make you religious. But because you're just doing stuff that we view as charitable but not religious, sounds a little bit like spiritual but not religious, that you don't qualify for this exemption. And so this went ping-ponged around in the lower courts. So first it went through a state administrative proceeding, then it went to a trial court in Wisconsin that ruled for my clients, for Catholic Charities. Then it went to a court of appeals in the state. They ruled against my client. We appealed that to the Wisconsin Supreme Court. That appeal is when I became involved. I argued the case to the Wisconsin Supreme Court and lost 4-3. And then we sought review at the United States Supreme Court. The Wisconsin Supreme Court opinion was, there's 4 judges for it, 4 justices rather, and they based it very much on what the taxing authorities had said all along, which is you're not doing things like proselytizing, you serve non-Catholics, so that was another sort of strike against Catholic Charities, and you don't have any sort of, you're not handing out tracts or, making people attend religious services in order to obtain these benefits or these, assistance. Therefore, you don't count as operated primarily for religious purposes. And they did, sort of functional test. There was a vigorous dissent from Justice Rebecca Grassel Bradley, and it's a little confusing because both the majority opinion was authored by Ann Walsh Bradley, and the principal dissent was authored by Rebecca Grassel Bradley. There's no longer 2 Bradleys on the court, so it's less confusing now. But she wrote a vigorous dissent and said, this is a real problem. You're basically picking and choosing amongst religious groups. So we brought the case to the Supreme Court. We sought review on a couple of different questions presented. One was the question whether the religion clauses, so that's the Establishment Clause and the Free Exercise Clause of the First Amendment, prevent Wisconsin from excluding us from this exemption that we thought we were entitled to. And then we also had a second question presented about what is the standard of review for a federal constitutional claim like that. And in particular, you have to prove it beyond a reasonable doubt. That the court initially granted both questions, but I guess had different thoughts over the weekend, and so granted on the Friday and took back the second question presented on the Monday. So in any case, it just became about the free exercise clause and the establishment clause. And we had some state claims before, like we said, this under state law, like we should win also. But of course, once you get to the U.S. Supreme Court, those fall away because the Wisconsin Supreme Court gets to decide what Wisconsin law means. So we presented three main theories of why Wisconsin's exclusion of my clients from the exemption violates the religion clauses. The first one that we had in our merits briefing was the church autonomy doctrine. So this is a doctrine that has been around for a long time. Anytime that government has felt like it's sort of interfering a bit too much in the inner workings of churches, judges have responded by saying, okay, we can't really do this. It didn't really have a name until Doug Laycock, a very prominent professor, wrote a very important law review article, I think in 1982, but early 80s, where he talked about the church autonomy doctrine, and that really kind of crystallized the area. So, any budding academics, write an article like that, you can have a big influence on the law. And so the court adopted it in the ministerial exception cases, and in particular, Hosanna Tabor was the first one that you mentioned earlier in your introduction. That was a Becket Fund case. And then in the Our Lady of Guadalupe case, which was in 2020, they specifically recognized that the ministerial exception, which they'd previously recognized, was a subset of a broader church autonomy doctrine. And so we said, well, this is a real problem in this case because you're basically slicing up the Catholic Church. So from the Catholic Church's point of view, Catholic Charities is the way they do charity in the Diocese of Superior. The church itself, so the body incorporated as the Diocese of Superior, doesn't carry out the charitable stuff directly so much as through this arm, but it is separately incorporated under Wisconsin law. So it doesn't make any sense from the point of view of the church to divide it off. But that was really, and the taxing authorities all along said, well, if you just glommed it all together in one corporation, we would, the whole thing would get the exemption. So that was our church autonomy argument. Our second argument was an entanglement argument. And there's a longstanding rule that you don't want to have what's sometimes we call excessive entanglement between church and state. And it was famously part of the Lemon test, which is now dead. So some people may be wondering, well, why is this still coming up? The reason is that the anti-entanglement concern actually predates the Lemon test. In particular, there's a case called Waltz against Tax Commission of New York that talks about it. But there's other cases, and the general idea is it's very much a sort of kissing cousin of church autonomy in the sense that you don't each area should have their own sphere of influence, right? The church has its sphere of influence, its sphere of control. The state has its, and you don't really want the state getting into the church's business or vice versa necessarily. Our third argument, which is the one that we ended up getting the decision on, is a rule about discrimination between religions. So basically, government can't have a rule that treats one religion better than another. The most classic statement of this case came in an Establishment Clause case written by Justice Brennan called Larson against Valente, which involved the Unification Church in Minnesota. And because they raised so much of their funding from door-to-door soliciting of funds, they fell afoul of a rule that said, well, you have to then provide lots of information about yourself. This was sort of related to like sort of anti-cult concerns or what have you in the 1980s. Supreme Court throws that out and says you can't discriminate amongst denominations this way. This is a denominational preference. And we think that idea is rooted in both of the religion clauses. So if you look at the Church of the Lukumi Babalu Ayek case, that's very much front and center there. It is a little bit odd kind of doctrine within Establishment Clause jurisprudence because it's the only part of the Establishment Clause that has a strict scrutiny affirmative defense. Every other kind of Establishment Clause claim doesn't have that. So those were our three arguments. The state's argument in briefing was essentially, we're just doing, we're just sort of a simple government here. We're just trying to distinguish between religion and non-religion. We're trying to stay out of all this. So they sort of embrace an anti-entanglement. We don't want entanglement. So we're doing here is trying to make sure we're not getting entangled. So that was their main argument that they relied on. They said this is just like deciding a ministerial exception case. They quoted my reply brief in the Our Lady of Guadalupe case to, I guess, troll me or something. But that was sort of their main argument. And they stuck very much by the position of the Wisconsin Supreme Court. The United States government also filed a brief in the case, and they took a different tack. They said, if you are, we think that this is governed by this Federal Unemployment Tax Act case. So actually, you can just decide this as a statutory matter. Now, normally, like I said before, the United States Supreme Court doesn't get to say what Wisconsin law is. But essentially, the U.S. government said, well, this is more or less an avatar. So the Wisconsin law is essentially an avatar of the Federal Unemployment Tax Act. And in some cases, based on a line of cases rooted in a case called Michigan against Long, you can actually decide this as a statutory matter. So that was their argument, which I can confess I didn't love seeing them come in with that argument, because I really thought that this was a constitutional case from the beginning. Just sort of foreshadowing it doesn't end up mattering. So the oral argument, ranged pretty widely. So my argument, was kind of in many ways, it felt a little bit like a law school seminar. I had this interesting colloquy with Justice Barrett about what is religion. And I didn't think they needed to answer that question to decide this case, and they didn't answer it. But I think it's a very, it was interesting because they were definitely testing, like, what's the outer bounds here. The Wisconsin Council's argument went a lot worse. I think, objectively speaking, he ended up getting tied up in a little bit of knots about, at one point he said, well, in order to qualify for this exemption as a soup kitchen, you have to ask somebody to repent before you give them the soup. So that really got a lot of reaction out of the justices during the argument. And so we, waited a couple months. We ended up with the decision. It was actually earlier than I think a lot of people thought, but that was probably because it was unanimous. So just the way the court works internally, it's, if they have a unanimous opinion, it doesn't take quite as long to issue it. So it's actually the first opinion from the March sitting. And it was 9-0, and it was written by Justice Sotomayor, who, after oral argument, I wasn't 100% sure was on our side, but she was, and she authored an excellent opinion. It very much relies on that third argument I mentioned, the Larson argument, about non-discrimination. It sort of repeats in a few different ways that, that's not really you can't do it. And I'll try to give you a couple of good, sort of flavor of it, but basically says, a statute that excludes religious organizations from an accommodation on the grounds, so such grounds being, whether they proselytize, etc., facially favors some denominations over others. And then it also says a law that differentiates between religions along theological lines is textbook denominational discrimination. And such official differentiation on theological lines is fundamentally foreign to our constitutional order. So, a lot of things like that. And one thing that I think is really important, going to be really important going forward, some people may say, well, this is just an application of the Larson case. It's just correcting the Wisconsin Supreme Court's error. But I do think it actually expands Larson a little bit in the sense of where you look for the word practice. So the reality is that the distinction here is not really along beliefs so much as the practices. So, it is true the Catholic Church doesn't teaches that you shouldn't condition, condition providing aid to someone based on whether they accept Jesus as their savior or attend mass or what have you. Um, and that is the root for the practice. But the discrimination amongst practices is what Wisconsin was doing, and the court does rely on that. So these are really theologically rooted practices, but it's very much about the exercise part of religious belief, religious exercise, and not the so much the belief part. And I think that's very important because some people would love to restrict this kind of rule to just the beliefs. So that's something to look at going forward. Justice Thomas wrote a separate or lengthy concurring opinion.
Before we go to Justice Thomas concurrence, just one quick
Sure.
question for you, Eric. As you mentioned, because some of Justice Sotomayor's opinion is taken up with this strict scrutiny analysis, which was interesting that within this denominational preference argument, there then is a strict scrutiny analysis that has to take place. And she actually spends a little bit of time on that. So maybe just a quick word or two about why here Wisconsin failed strict scrutiny on that.
Right. No,
If
that's
you're in the Larson v. Valente category, denominational preference, strict scrutiny applies. Why does Wisconsin fail strict scrutiny?
right. No, that's excellent, and I definitely should summarize that part of it. So the first thing is they summarize the Wisconsin stated interest. So the strict scrutiny test says that the government has an affirmative defense, so they bear the burden of proof and burdens of proof and persuasion to say that they have a compelling state interest in that is narrowly tailored or is the least restrictive means of obtaining whatever the interest is. So you have the government has identified a compelling interest, and it is pursuing that by the narrowest means possible. And the way the Supreme Court or Justice Sotomayor in the opinion for the court says there's really two principal interests that Wisconsin invoked. One is that it says that the argue serves the law ensures employment coverage for its citizens. There, the court then looks at, well, does it really follow this interest carefully? And it really doesn't. And I think she said there's over, it's the Wisconsin exempts over 40 forms of employment from its unemployment compensation program. So we'd of course listed many of these in our briefing, but I guess her clerks counted them up. We didn't actually get a number. So if it's riddled with all these exemptions, then it's very hard to say it's a compelling governmental interest, right? Compelling means you're sort of compelled in every instance, not sort of riddled with exceptions. So that I think was the first response. And then the second argument that she identified that the state said is that it's to avoid entanglement. So again, this was that argument that I felt like was one of their main arguments, which is just like we're just trying to keep church and state separate. It's okay, and we obviously agree. Like you should be able to keep them separate, but not at the cost of essentially penalizing people for having particular religious beliefs. Justice Sotomayor ends up rejecting that argument by saying that it's not closely fitted to that. And that the state, she says, the state again fails to demonstrate that the law here is closely fitted to further the anti-entanglement interest, and it doesn't explain why the rule applies to the entire organization as opposed to individuals like a priest or something where you'd be worried about some kind of entanglement. There's no entanglement if the janitor is being fired and needs to get unemployment compensation. And since the law was not designed to fit that interest or supposed interest, that didn't suffice. And I will say about those two interests, the first one they'd been arguing all along, right? They said we need to get maximize state unemployment compensation coverage, which of course means maximize the amount of money going to the state, right? So let's be honest, like that's the ultimate thing here is like how much of this tax can we collect? That was their argument all along. For the first time in the United States Supreme Court, they start making this anti-entanglement argument, which, so we kind of felt like they'd almost waived that argument, but this court obviously goes ahead and addresses it. Does that kind of summarize that one pretty well? So
Yes, yeah, I think that's very helpful. Then, as you mentioned, Justice Thomas writes a concurrence on this church autonomy principle that you'd mentioned earlier. So maybe say a little bit about what he's. I should say both he and Justice Jackson also concur. They join the court's opinion, so it's 9 clean votes for the holding. But there is this concurrence that adds the church autonomy principle. So maybe say a little bit about that if you would.
sure. So, people talk about belt and suspenders rulings, and we got the belt from the opinion for the court by Justice Sotomayor, and then we get the suspenders from Justice Thomas. He does a really great, what I would call a classic Justice Thomas deep dive into an area of law that can be confusing, but does really a great job, to my mind, of explicating church autonomy doctrine, explaining where it's rooted, explaining what it's based in. He says there's sort of 3 sources for it. One is the right of association. Another is matters of the protection for matters of religious faith and doctrine that are closely linked to matters of church government. And then third is just the understanding that church and state are 2 rightful authorities, each supreme in its own sphere. And this sort of spheres theory of church and state is something that's been, I would say, talked about a lot in legal scholarship, not quite as much in legal opinions. This is a great explication of it. He cites to a really great article by Professors Renaud and Lyle Weinberger, and basically, is rooting it in this idea about the fact that there's really sort of spheres of authority. So it fits with the classical American conception of the state is not sort of doesn't predate us, it doesn't control us. It's something that is there to serve a certain kind of purpose, but it is not a total state. And there's other institutions in the world that have responsibilities and authority as well. And so, and then he goes into some of the history there. And, he talks about like, well, what does this mean for religious institutions? And he says, well, they do have to have a corporation, right? Often they need to be incorporated so they have legal identities, so they can buy property, engage in contracts, and but he says that essentially he says the corporation is serving the religious body, not the other way around. And actually, I should pull up the exact quote. I want to make sure I get this because it's a good quote. He says, in short, the corporation is made for the church, not the church for the corporation. And both the basic principles of church autonomy and the history of religious corporations establish that religious institutions are more than the corporate entities that they form. It follows that the government may not use such entities as a means of regulating the internal governance of religious institutions. So I think that's like a really important point in the jurisprudence of this area. And really, this is one of the clearest, if not the clearest, statements of that doctrine. I think it's really excellent. And I think, so I do think actually, one of the effects of this case, in addition to the fact that we've got, some very helpful explication of the Larson non-discrimination standard, but also and strict scrutiny in this context, I think that this Thomas opinion will end up getting cited in a lot of courts dealing with church autonomy claims, which have grown a lot as, essentially as the administrative state grows, you end up with more conflict between these 2 spheres. And so, there's more need for church autonomy doctrine to come to the fore. Then just a quick word about Justice Jackson's concurrence. It really kind of continues what she was focusing on it argument, which was very much the U.S. government's brief about FUTA and this federal statute and whether it, you know, require, what does it require in terms of analysis. Um, she says that it's okay for states to look at the functions, what are they doing? I think to be honest, I think it's a little bit hard to reconcile with her joining the court opinion for the court in full. There's like a little bit of cognitive dissonance there. But I don't think it's going to end up mattering too much. Just because I don't think, the reality is like FUTA doesn't require states to enact a particular set of propositions. It just says you have to be in a certain zone. You need to provide certain kinds of relief, but you don't have to do it in a particular way. And so I think that is, I think that makes the FUTA point probably somewhat less relevant. So that's really where we ended up. I do think it's going to be, like I said, an influential opinion. It's not a, employment division against Smith kind of important case or things like that. It's not, I wouldn't call it a, world path breaking kind of case in terms of just being way out there. I know that goes against my interest. I have to say that my case is the most important case out there, but I think it's a very important case. I just don't think it's, it doesn't recast the entire area of law. So.
We should talk about some applications of it. I'm also mindful that we want to get to some audience questions. Again, you can put them in the Q&A function at the bottom of the Zoom window. So one person is asking and anticipates a question that I was going to ask already, and that was about applications. And application, this expansion, if to the extent it is of the Larson versus Valente principle, and in particular maybe some pending controversies about the scope of exemptions to which this might be applicable. And I know there's a Beckett Fund cert petition pending right now, along with the Jones Days Council and this Diocese of Albany case. So maybe you say a little bit about that and perhaps its relevance here.
Sure. So the sort of discrimination amongst religious groups based on their practices, including how they're organized, is something that's been around for a while, and has come up particularly in some of these cases involving what's typically called a contraceptive mandate or an abortion mandate. There was the federal one, which resulted in under the Affordable Care Act, that ended up resulting in the Hobby Lobby case with respect to private and not for-profit companies, and then the Little Sisters of the Poor case, Zubik, with respect to the nonprofit organizations. So that issue reached the U.S. Supreme Court, but it also comes up frequently in state courts, state systems, that is, and there's a number of states that have passed insurance mandates where they say if you're going to have health insurance for your employees, you must include abortion coverage in there, or you must include contraceptive coverage. And that obviously causes a problem for many different institutions. They typically will have a small carve out for churches themselves. So the Diocese of Superior doesn't have to do it in that kind of situation, but it would affect the Catholic Charities potentially. And so there's been a few of these cases over the years, in particular prominent ones in New York and California. Currently, there's one that already reached the United States Supreme Court once and got what's called grant vacated and remanded in light of the Fulton case a few years ago. And it's back up another time on a cert petition that we have along with Noel Francisco at the Jones Day law firm. And that case apparently was being held for this one. So we'll have to see. Usually that means relatively soon after the decision that it was being held for comes out that they will act on that. We think it's an appropriate case for summary reversal based on the Catholic Charities decision, in part because it's been lingering for a very long time, and sending it back with another GVR would really extend the amount of time that these religious nonprofit entities have had to be litigating this case. So, so I think, certainly we would view a summary reversal to be appropriate in light of the Catholic Charities Bureau decision.
Here's another question posed by someone in the audience, which is an important background issue here, I think. Person asks, there is no requirement that an unemployment compensation scheme provide a religious exemption at all, right?
That is true. That is true. So, for example, Hawaii, they have a much more limited one, and it doesn't cover. I don't know if it covers religion at all. Now, I do think that there might be a claim under the Constitution under a different, sort of theory, but basically to say like, look, if you're providing an exemption to all these other nonprofit organizations, for example, uh, Wisconsin exempts, as Justice Sotomayor pointed out, a number of other organizations from paying this tax, to then say, well, religious nonprofits don't get it. That could be a problem. But I do agree, like the law, the Federal Unemployment Tax Act does not require you to have it. And so, for example, Hawaii does not, would not cover Catholic Charities. And I'm not sure, I don't think it would cover the Diocese of Superior in this instance. So, and our argument all along was like, we're not really arguing about whether you have to have such an exemption. We're just saying once you have a religious exemption, you don't get to pick and choose which religions get it based on, essentially theological differences.
Another question, does the court's opinion reinforce the growing trend in the court's religion cases to essentially meld the establishment clause and free exercise clauses into an anti-religious discrimination framework? I think you talked about this on the courthouse steps about the oral argument that rather than reading them in opposition, there's a growing trend perhaps to read them in combination, so to speak, and to what extent does this case maybe illustrate that as well?
So I do agree that the religion clauses should be read in pari materia, right? So read together because they're literally part of the same sentence. And the court points this out in the Kennedy case, the Kennedy against Bremerton School District case. It says this idea that they were supposed to be like opposing clauses has never made any sense because they're written by the same people, put into the same sentence. They weren't meant to be in tension with each other. That just sort of came up later in the jurisprudence. And so I definitely agree with that. And I agree that it can be helpful to read them together. We kind of laid out a little bit of a topology of the jurisprudence in this space at the beginning of our opening merits brief in this case, to just say like, look, there's some cases that get decided under the free exercise clause, some under the establishment clause, and then there's this third category of both clauses. And we would say church autonomy falls there, but also things like courts answering religious questions. That is something that isn't something that the state shouldn't be doing, but just because it's the state, but also harms churches or synagogues or other religious organizations by meddling with their internal organization. So I agree with all that. I think the part I wouldn't agree with is this idea that it's sort of the resulting, sort of symbiotic relationship between the two is just anti-discrimination. So I definitely think there's an equality interest. And actually, Justice Kavanaugh has written some of the most interesting stuff on this over the years in concurring opinions. But there's also a liberty interest. So there's definitely an interest that goes beyond in the free exercise clause and in the establishment clause that goes beyond just equal treatment. It does say we need to affirmatively accommodate certain things. So, classic examples like kosher food for prisoners, and is there a right to get something like that? It's now protected by federal statute, but I think even before then, we would say, yeah, you really need to accommodate kosher food, even though it's not equal. It's like a different treatment than other prisoners, but these folks have a religious set of religious beliefs that really requires them to do it. And so we want to back up from that conflict of obligations between religious obligations and civil obligations.
Another question, which again, I think echoes some things also that came up at oral argument and are sort of left here in light of the court's opinion. Given the court's emphasis on denominational neutrality and avoidance of theological line drawing, What standards should courts and administrative agencies adopt post-Catholic Charities to determine whether an organization is operated primarily for religious purposes without violating the Establishment Clause or triggering strict scrutiny under the Free Exercise Clause? So kind of what, in terms of the line drawing, Justice Sotomayor said at the end of her opinion that, what is it? That there may be hard calls in policing that rule neutrality between religion and religion, but this is not one. So what are the criteria now that, as the questioner asked, that courts and administrative agencies should look to in terms of determining whether an organization is operated primarily for religious purposes?
Right. So I think you have to look at it. It's going to be focused much more on uh what is what is the person doing and why are they doing it? And so, the first cut, and I think this is really the concern that drives a lot of these questions, is sincerity. So, uh a lot of several statutes require courts and administrative agencies and state agencies and prison wardens to look at the sincerity of religious beliefs. It's not evaluating whether I think it's true. Do I think Judaism is true? Do I think Sikhism is true? Do I think Buddhism is true? No, it's not that. It's looking at whether that person truly believes that. And that's a state of mind question. It's something that courts, government officials, everybody has to decide all the time. If you make any case involving mens rea, is going to probably require, or any kind of intentional mens rea is going to require somebody to figure out what's the state of mind of this defendant. Same thing with, conscientious objectors in military service. You have to kind of make up your mind, like, do I think this person's telling the truth about their beliefs, even though I don't share them? Maybe I think they're very strange beliefs, or I don't really think they make sense to me. That's not the question. The question is, does this person believe it? Because that's the rights-bearing entity, right? The person. And so I think that's actually like a pretty good first line to draw for any governmental official or entity trying to figure out, okay, is this person engaging in religious activity? And then the second thing is actually what I would call the religion versus philosophy divide. So there's a lot of this comes up sometimes in prisoner cases. It's come up some in the vaccine cases. So people have an objection to vaccination. Sometimes they'll just say, like, well, I don't want to make my body impure, but it's out of a sort of a philosophical need. There's no sort of religious obligation, transcendent obligation that is requiring them to do it. They just think it's the best thing to do. That's more the philosophy side of the line. And then the religion side is more, to put it sort of bluntly, is God telling me to do it? And the court actually addressed this in a very famous passage in the Wisconsin against Yoder case, where it distinguished the Old Order Amish plaintiffs in that case from Henry David Thoreau, who, famously went to the, Walden Pond and lived a very simple life in the woods. And I think that was the comparison, is like they're both living simple lives in the countryside. But the court said, but the Amish are doing it for religious reasons. Thoreau was doing it for very deeply held and very important philosophical reasons, but those are not covered by the religion clauses. And I think that's actually a really important difference and it's something that government entities across the country decide all the time. So I think those are really good things. I think the sort of flip side is I think a lot of judges or government officials sometimes shy away from deciding the sincerity question. They're like, oh, well, I can't tell somebody what they believe or not. You have to really distinguish between the, like, what do they believe, and can I, like, discount that because I think it's, I think it's silly or wrong or what have you. And, like, are they really thinking it, or are they just trying to put one over on me? It's totally fine to decide the second question. And in fact, it's better for religion and religious liberty if you do decide it. Because if you get a whole lot of boys crying wolf, that actually ends up lowering, kind of debasing the currency of religious freedom. So I think it's good for government officials to think about that sincerity issue.
Again, we have just a few minutes left, but if you have any questions, you can place them in the Q&A function on the window here. Touched on this a little bit already, but I'll ask this question for you to expand on it. Does the reasoning of this decision depend upon the unemployment and compensation context, or is it broad enough to cover government contracting or government payment for a religious entity's secular social services, such as care for children, elderly, disabled, or poor? I suppose we could add healthcare as well. So again, another question about application and scope of this holding.
So I think it applies to all of those things. I think it's definitely not restricted to unemployment compensation tax exemptions, and the court doesn't put it in those terms. And of course, the Larson case that it's relying on didn't have to do with unemployment compensation taxes either. Um, I think that it's likely to be relevant wherever government is sort of deciding among different religious practices and sort of saying like, I favor this religious practice over this religious practice, not necessarily because they're religious, but just because they're different and we don't really like the difference. I think that those kinds of cases are going forward. That's why I think this Diocese of Albany case is, could just, get decided pretty quickly based on this Catholic Charities Bureau case, even though that's not a benefits case. It's not a tax exemption case. It's actually about having to comply with a mandate. So it's sort of a burden, what people think of as a burden case. But I think it squarely applies to that.
Uh, I'll take one part of another question, and again, something you touched on earlier, but I think it's worth expanding upon. And this person asks about, will entanglement survive the death of Lemon? So as you mentioned, there was church autonomy arguments, entanglement arguments, denominational preference arguments. The court's opinion relies on the latter. Justice Thomas concurs on church autonomy, but entanglement didn't seem to get much attention here. So I guess the question is there still a lot of play in the entanglement arguments, even with the demise of the Lemon test?
So I do think that entanglement is still around. And as I think I mentioned earlier, the entanglement test predates Lemon. So Lemon is now abrogated. No one said the O word yet, overruled, but it is overruled. It's abandoned and abrogated. So I think it's not valid law anymore, and it's got that little red flag in Westlaw. But I think that but that doesn't mean that everything that's in Lemon is out too. And one of the things that it said is, we don't want this kind of entanglement. I think that the form of it in Lemon was in some ways anti-religion. So that wasn't really a very helpful way to do things. And I think that's part of why the court rejected the Lemon test in the Kennedy case. But the Waltz case, like I said before, predates it. And I do think it's an inevitable aspect, at least, of church autonomy doctrine, because uh, ultimately, if you really think that there's separate spheres where, the church has control or the state has control, um, you know, at some point you have to have a rule, you have to have a fence between the two of some sort, I like to think of it's not a wall of separation, or if it is, it's sort of like the little short wall in Mending Wall by Robert Frost, where they go along and just sort of put the rocks on top, just to kind of delineate, like, okay, this is my side, this is your side. I think that kind of thing is inevitable, and I do think that right now the main danger is not so much some religious organization taking, control of a governmental body, so much as it is governmental bodies coming in and, controlling aspects of religious organizations that they ought not to.
Someone asked about another case in which I know the Beckett Fund was involved, and that's Fulton. Someone asked, how is the rationale in this case the same and different from that in Fulton? So kind of differences in, I suppose, sort of doctrinal distinctions in how those two cases were resolved.
Well, that's very interesting because if you search the opinion, you'll find that Fulton does not appear in this one. And Fulton was this was a case involving Catholic Social Services of the Archdiocese of Philadelphia. So actually a very parallel organization, Catholic Charities type of charitable arm of a diocese, like our client in this case. But there, they were being excluded from participating in a particular foster and adoption services contracting because certain beliefs about, they just were not able, in accordance with their religious beliefs, to place kids with same-sex couples. And there were plenty of other bodies that would do that, so there's no problem actually doing those kinds of placements. It was just that they themselves could not do it. And I would say, in a way, it does, they do end up sort of following parallel courses in the sense that they are both about not discriminating unnecessarily against religious organizations. It's just that the difference there, this case is about where you already have a religious exemption. Can someone get into it? So it's really religion versus religion, whereas that one was not so much. That one was more about a religious body being kicked out of a secular program and not being able to contract with it.
We'll take one more question here. Would this case apply to a religious hospital or school not wanting to participate in unemployment insurance?
Um, well, I actually think that's a very interesting question. I do think that drove a lot of the discussion at the Wisconsin Supreme Court. Um, I think it's possible that a hospital could try to say, oh, we don't want to do unemployment compensation tax, etc. Um, I think they would have to be church controlled to do that. And that might be a limit on some entities. So it's not just like you have a religious affiliation, you may need to be church controlled. Um, but I also just don't think there's the appetite for some of these large, for example, Catholic healthcare systems. They've never indicated any interest at all in, trying to do that. And the reality is, like in our case, the reason we wanted our clients not to have to pay into the state system is because we have a much better system that the Catholic bishops of the state of Wisconsin have. It pays the same amount out in terms of amounts, but it's much quicker and more efficient than the state system. So essentially, if you use the state system, you're going to wait quite a while to get your unemployment check versus if you're doing it through the Catholic bishop system. So I think, in many ways that might be a better system for a lot of workers.
Well, we've covered a lot of ground, answered a lot of questions, and comprehensively tried to discuss as much as possible about this opinion from yesterday. Any final thoughts, Eric, as you take your victory lap after winning this argument, winning this case in front of the Supreme Court?
Well, I don't want to take a victory lap because I think it's, from my point of view, this is the right decision. It was always the right decision. And, it's unfortunate that the Wisconsin taxing authorities essentially picked this fight with the Catholic Church. But I also think it's something that, it does mean something that it was unanimous. I think the fact that, so many people think of religion as this hot button issue that's very divisive and, nobody can even, you're not supposed to talk about religion in polite society or something like that because it gets people too angry. But you see this, court that often is quite polarized over certain issues, and you get all of them saying this is just not the way we do things in America. And Justice Kagan said something like, "I just thought this was like a fundamental principle." This is an oral argument when she was talking with Wisconsin's lawyer that you just don't pick and choose among religions. And so I think that ought to be reassuring to people that uh, the court is doing its job, and I think that's really very helpful to American society. And one can dream that it might even reduce some polarization.
Well, thank you again for joining us today and covering the details of this opinion in the case that you argued a couple months ago. And thanks, as always, to the Federalist Society for their help in putting together this program. And with that, we are adjourned.